Right, good morning, everybody. Welcome back for what I think we hope is the last day of evidence in this inquiry. Hope you all had a decent weekend. Personally, let me get this out there. I spent most of the evening that we resumed sitting on a bench in King's Cross Station until midnight due to train cancellations. So that was a great start to the weekend. However, I hope you all had a better weekend than I did. It improved after that. I've got just a couple of housekeeping matters. I need to pick up at the end of today the arrangements for the site visit. We can leave that for the moment. Various things that are outstanding, we know about those. And again, I'll pick them up later on. I think the only thing I need to raise at the moment is that about 10 minutes ago, I have seen an email from a Mr. Simon Clark sent to the council and then forwarded on to the inspectorate and then sent on to me. I think that was the gentleman who was here on the first morning, but then couldn't on the second morning. I haven't gone through my notes. Simon Clark. Oh, no. Well, he begins by saying, sorry, I haven't read this email, to be honest. He said he attended the second day of the appeal, spoke to the inspector to ask him if there would be an opportunity to speak, and he directed me to submit my comments in writing. I have to say I don't recall that. In any event, he has now submitted his comments in writing, which I've only skip read. It's a page and a bit and a hand-drawn plan. Mainly, if not exclusively, dealing with mentions obviously national landscape, but he mentions various other developments. I have to say, without checking my notes, I don't recall the gentleman. Have the parties seen that?
I haven't seen it, sir. Simon Clark was one of the people who had indicated they wanted to speak on day one, but I don't think we're here.
Yeah.
So I don't remember. Yes, Simon Clark. Yeah, so he was on the list of people that you had that indicated they wanted to speak, but he wasn't here. But I haven't seen that, no.
Well, obviously, it's in opposition to the proposal. It is mainly related to other developments and planning matters. It's obviously very late, but I'm reluctant to turn it away. So I think what I'll do in just a moment, it's come via the council, so presumably the council's seen it, but what I'll do is ask the case officer at PINS to forward it on to the parties. You've obviously got your planning witness here today who can deal with it. So actually, if you can just all bear with me for a moment, I'll deal with that now, get rid of it. Yeah, and obviously, Mr. Marici, if you need to have a word with your witness about that, that's absolutely fine, of course.
Sir, can I just ask who at the council sent it to you? So I know who's got it at the council to ask to see it.
It was sent obviously to the case officer, I must mention that. My case officer said sent from Mr. Clark via the ACP.
Okay.
Yesterday.
We'll find it, sir. We'll find it.
Don't know what ACP is, I'm afraid. But I've asked the case officer to copy it round in any event, and we can deal with it in some way. Just on that matter, I don't know if an email has gone out or not, but although any emails to PINS that are incorrectly addressed will be forwarded, but the case officer is now Helen Skinner from now onwards. I think they were going to send out an email to that effect. Not to worry if things have gone on into Holly Dutton, who's now on maternity leave, but it's Helen Skinner from now onwards for any correspondence. I don't think I need to pick up on anything else today. As I say, mostly it's checklist of things that are outstanding and arrangements for the site visit tomorrow. Any housekeeping matters?
So there's
Yeah.
there's a couple of things. So I've got a plan that I've given to my learned friend that I want to put in, which he has agreed to. Effectively, it just shows the whole of Waverley Borough Council and which areas are green belt, which areas are national landscape, which areas are proposed to be expanded national landscape. Because obviously there's been a discussion about land elsewhere. So it's just a map. I mean, I think as my learned friend pointed out, it's probably actually a putting together of several maps we've already got in the.
I was going to say,
just
I
overlaying
think
on-
I've seen all that information.
Yes,
but it's
but
helpful to have
have
it
it
in
on one map. Yes. So I'm going to hand that in.
Yeah,
And
please.
so my learned friend's got a document, a recent case which he wants to put in, which is fine, which we'll come to in a moment. The other thing is on conditions and 106.
Yeah.
I think we are hoping to be able to submit the revised agreed set of conditions to you this morning, and we'll put them into the inquiry documents. So we're there on conditions, as I
Okay.
understand it. Yes. And then I think we're also there on the 106s. So we're hoping to get the final versions of those in to you and into the inquiry documents this morning as well. So you'll
Okay.
have those.
No, that's great.
Although I think so, we did agree, didn't we, that we were going to deal with conditions in 106 when we come back for closings, or when we do closings remotely, I think.
Yes.
Yeah.
Yeah, I should have mentioned that actually. I mean, I've got no idea if anybody's with us on live stream. And I will try and remember this when we close today, but the session on conditions, I was trying to find it. Trying to find the date that we've got for closing. 6th of May. Sorry, I've jumped over it. Yeah, got it. Right, so the session on conditions, session on the 106 obligations and closing submissions will start at 9:30 Tuesday, 6th of May. I'll try and remember to mention that when we finish today as well. I don't know if that information is on the council's website yet.
It is, I think it is, because we've set up the group and I think it's
Excellent.
gone onto the
Thanks.
council's website.
So anybody who, well, as I say, I'll mention that again this afternoon when we close, but anybody who wants to join in on that session, listen to that session, more than welcome. Okay, yeah, other housekeeping matters.
So yes, thank you. Just one case which only came out last week, which it's in the Court of Appeal. It's a case called Frack Free Bolcombe Residents Association against Secretary of State. It deals in a general sense with the issue of alternatives. So Keith Lindblom, who's you may recall, so as the judge who dealt with it in Wealden, refers to Wealden. It's different context. It's about oil, drilling for oil. But he talks about the generality of approach to alternatives in a few paragraphs. It's going to be relevant for closings rather than any evidence today.
Right.
I've emailed a copy to I've had emailed a copy to the Rule 6 party because I only made one extra hard copy for you.
Thank you. Thank you. Okay, anything further from anybody? Okay,
So the only thing was I've just seen, sir, that we got an email yesterday from Helen Skinner to say that the Scouts had put some further stuff in, which I've only just seen now. I haven't looked at it at all, but
I haven't seen that.
So I've just had it come through now. So I haven't
From
read
Helen
it.
Skinner now.
Well, no, Helen Skinner sent it yesterday,
Oh,
I think. Is that right? Yeah, she sent it yesterday.
I haven't had that.
It went to Hazelmere South, and it went to at least one Waverley email address.
have you got a time on that? email?
So Helen said,
Eight-
it's going to say
8:40.
8:40, yeah, 8:40
8:40,
AM.
yeah, we've got it, but there's nothing new in there. We haven't seen anything different or any new news in it.
Oh,
No. Well, so I think, the difficulty is, of course, my case has ended. So can I just say the practical ways for us to look at it? If we need to address it in some way, we can just decide whether we need to put something in writing or whether we do something else. Or
I'll pick that up because I did have I had an email from Helen Skinner at 8:09 yesterday, but it wasn't that.
Is the date, is the timing of the email that was sent out to ourselves, the council and the Rule 6 party, 8:40 a.m. And then the email from the Scouts looks like it came in on the 17th of April. I wonder when that was.
Hang on.
Yeah, so it looks like it came into pins to Holly Dutton on the 17th of April. Yeah, so last Thursday, yeah. So I don't know whether it came to you sooner.
Right. It may have done. I'll have a look for that. It does actually ring a faint bell. So I suspect I've seen it, but it sounds like the council may not have done.
probably the council in inverted commas has, but I haven't.
Yeah, okay. I will have a dig around for that in my inbox and we'll see where that goes. Right, anything further? No. Okay.
Sorry, but it does ring a bell with me, because I think you did mention one of the mornings last week you'd received some information from the Scouts. You'd looked at it. Some of it you determined not to let in because it raised news. Some of it, we had that discussion.
I think that was something else.
That was a different one.
I think
right?
that was a different one because this
Okay.
one looks like it's come in from. Sorry, just give me 1 second. I think if you remember, that one talked about instructing solicitors, and I
Right.
think this one's come in from solicitors. So
Right.
it's come in from some
Yeah.
Gordon's Partnership solicitors.
I think I've seen that, but it's obviously important that the council sees it.
Well,
And
I can forward it now straight to. Shall I just forward
if
it?
you, I'm pretty sure I've got it.
Yeah,
But if you could forward it direct.
I'll forward it to Mr. Cosgrove.
And obviously we need to have a look at that in terms of how we deal with it, given the stage it's reached.
Okay, I've just
I
sent
mean,
that.
I'm always very reluctant to turn things away, but there does come a time when you actually have to do that. But I'm not saying we do with that one.
No, I've sent it over to Mr. Cosgrove.
Right,
So.
let's have a look at that Scouts letter at some convenient point during the day. Okay, that aside, Mr. Marucci, over to you for your final witness.
Thank you, sir. So can you confirm you are Charles Collins?
Good morning, everyone. Yes, I can.
You hold a BSc Honours degree in Geography and Economics and an MSc degree in Town Planning, and you've been in private practice since 2007, having started your career in local government in 2003, and you're a director with Savills, correct?
That's correct, yes.
You set out in your main proof in section 1 in more detail your experience in relation to other schemes and also your knowledge of the appeal site and its planning history. In brief terms, how long have you been involved in Scotland Park phase 1 and then phase 2?
About 6 years.
About 6 years. Thank you. And then at the end of your section 1, you give the necessary declaration that the opinions expressed are your true and professional opinions and given in accordance with the guidance of your professional institution. Does that apply to your proof, your rebuttal, and the oral evidence you're about to give?
Yes, it does.
Okay, thank you. So could we please just start by, could you just give us an overall introduction to the scope of the matters that you're going to be covering this morning?
Good morning, Em. Good morning, sir. Obviously, I'm covering town planning matters and general matters in response to third-party representations, policies, etc. It may be worth picking up the statements of common ground in respect of where we are in terms of the outstanding issues as I see it in planning terms.
Yeah, so that's NID 4.11.
That's correct, yeah. So you'll be aware that there's one main outstanding principal reason for refusal, and that is outlined in the statement of common ground from paragraph 1.9 onwards. Originally, when the proposal was refused in May 2023, there were 6 reasons for refusal. I accept obviously that ecology is still at issue between the appellant and the Rule 6 party, but the other 5 issues have been resolved with the Borough Council, which leaves the main reason for refusal, that being landscape.
If we go to section 5 of the statement of common ground, this sets out, doesn't it, a list of the matters in dispute between ourselves and the council at the date of the statement of common ground. I think there are eight in total. Do you want to run through where you consider we are on those?
Yes, of course. So the landscape terms, the council are alleging a greater impact on the landscape than the appellant. Obviously, that's been covered by Mr. Andrew Smith for the appellant. On housing, it's common ground that the land supply is 1.28 years. I think there is still a small disagreement in terms of the weighting that should be given to housing as a benefit associated with the scheme. Exceptional circumstances clearly is at the centre of this inquiry, and that is an area of disagreement. Appellant position is there are exceptional circumstances. The council is that there are not. In respect of the application of the NPPF, I think there's broad agreement in respect to the most important paragraphs. I'm not sure, following Mr. Johnson's evidence, whether or not there's entire agreement on the operation of paragraph 11D, but no doubt I'll come back to that in my further evidence. In terms of the development plan, there's a difference as to whether or not the proposal is compliant with the development plan when read as a whole. Difference between myself and Mr. Johnson on that. And on the planning balance, there is some agreement on the weight to be given to some of the benefits, but there's some difference on the weight to be given to some of the benefits, and there's obviously a difference on the weight to be given to the harms. Well, the extent of the harms, and then the weight, which obviously then leads to the overall balance and conclusions.
Yeah, and obviously we've got in the statement of common ground at page 9 onwards, agreement on the local plan policies, LPP1, LPP2, that are relevant and those that are in issue. And I think we know by now the ones in issue with the council: SP2, RE1, RE3, DM11, DM15 and H9 of the neighbourhood plan, and we'll come back to those. Are there any other important policies, so far as you're concerned, for the determination of the appeal? Obviously, there's a number of other relevant policies which are agreed not to be breached, but are there any in particular that you say are important to the determination of the appeal?
So in addition to those 5 policies you just mentioned, Mr. Marici, I would say that ALH1, AHN1, TD1 and NE1 are important policies as well.
And those are all obviously agreed to be
complied
with.
Yeah.
Okay. All right, we'll come back to policies in due course. So before we get going, are there any clarifications or corrections in your proof that you need to make?
Yes, so you'll be aware that in my table 4.1 in my main proof, I go through.
So this starts on page 26.
26, yes. I go through a number of policies that I feel are relevant for the determination. You need to read that alongside my rebuttal. And the relevant page on my rebuttal is page 3, table 1.1. And that provides commentary against policy DM13, developments within settlement boundaries, essentially to confirm that it's not applicable because the site, you'll be aware, so is outside of the Hazelmere settlement boundary. But to clarify my commentary in my original proof on DM15. So essentially what I'm saying is do not read my main proof, page 38 on DM15, read table 1.1 in my rebuttal.
Okay, thank you. And it's table 4.1, subject to that correction, which deals in detail with your account of where you see compliance or non-compliance with individual policies. Is that
Correct,
right?
it
Yeah.
does, yeah.
Okay. Now, we've again, before we sort of get going on the main issues, we've heard a number of representations and heard evidence from both the Rule 6 party and third parties on a range of matters going beyond the main issues. And I'm not going to ask you to address all of those, but there are two in particular I want you to address briefly. One is, where are we in relation to this scheme with Thames Water, please?
And there's no objection to the appeal proposal from Thames Water.
Thank you. Secondly, and again, I think we do this very briefly, there was a suggestion made by a third party that the original vision was for 4 phases of development on this site. Is that correct?
There's never been 4 phases, as it were. There's only ever been 2, in inverted commas.
Yeah.
So we're dealing with phase 2 now. I think, and this development document, I think is NID 13.12, sir, and NID 13.13. I was involved with the exhibition and the consultation back in 2019, and within that there was a plan that showed 5 character areas.
Yeah.
And that,
But not phases, not
But not
phases.
phases.
No, okay. All right, that's fine. Now, I'm not going to ask any more questions about any third-party reps. So obviously, if you have any questions for Mr. Collins about anything that's been raised, you can ask them in due course. Can we come to, please, the site context and insofar as we need to at this point, the planning history. This is set out in the Statement of Common Ground at section 2, also in your proof at section 3. Are there any kind of wider contextual points you just want to briefly draw the inspector's attention to?
so yes, so there's no relevant planning history on the site, sir.
Apart from this
Apart
case?
from this case,
Yeah.
which obviously there was a previous inquiry for.
Yeah.
The design and access statement, which I don't think we need to go to because you'll be familiar with it already, sir, demonstrates the context well. For example, the surrounding landscape context, the designations, etc. Also, I'll draw your attention to figures 4 and 9 of Mr. Andrew Smith's proof. And my proof, figure 6.1, demonstrates potential extensions to the AONB, but of course there's the plan which has been introduced to the inquiry today, sir, which
We'll
shows
come
that the
to,
rest.
yeah, we'll come to that. So again, for the inspector's note, I mean, when the inspector looks at the design and access statement, in terms of the landscape context, the designations, DAS page 15, I think is the right place. And in terms of site accessibility to local services and amenities, which is not in dispute with the council, that's shown on DAS page 17, is that right?
Yeah, that's correct. So
Okay.
there's an accessibility plan there. And then also in the DAS addendum, sir, page 29, there's a helpful plan there which shows the distance from the site to local services and amenities.
Okay. I think that's all on that for now. I suppose I should just ask you, in relation to, we'll come to this when we look at the plan, but obviously there's an ongoing AONB review that's seeking to extend the AONB, both in this borough and beyond. Can you just give us a brief timeline, so far as you're concerned, about what's been happening on that and where it's likely to go?
Yeah. So I was involved with the first local plan examination, so the LPP1 examination, which was 6-7 years ago. If you look at the inspector's report for that, Inspector Bohr, it's a CD 7.57. That confirms that the prospect of an AONB review was alive back in 2018.
Yeah, so that's para 137, isn't it? Of
It
that
is
report,
paragraph
yeah.
137. And that's how policy RE3 was constructed essentially, which was you have the AONB and the AGLV, but the AGLV, there's an awareness in the policy that was to become or potentially become AONB at the time. I do have another role as Secretary of the Surrey Development Forum, So, which is an organisation of developers operating across Surrey. So we've been monitoring the AONB review closely. First consultation was back in December 2021. There was a second consultation March to June 2023, and a third consultation last autumn, autumn 24. Now, in all of those consultations, they showed sort of gradual expansions, if you like, of the AONB. The broad terms of reference for the exercise have been to look at areas which are candidate AONB, so valued landscapes in the eyes of Natural England, which they obviously are proposing becomes AONB. I'm using the old term here, but it's always been known as the AONB review, but you know what I mean. The only areas where there's been some contractions have been for minor clarifications of the boundary.
And I think we've shown, I don't know whether you've got the plan to hand, but I think those are shown, aren't they? So we've got, if we just look at the plan, you've got the district shown with the black line.
Yeah.
There are, where you've got smaller areas of land coloured green. So for example, in the bottom right-hand corner, those are areas of ancient woodland. We've then got the green belt with side hashings. You can see the extent of that. You've then got the Surrey Hills National Landscape as currently designated in dark green. And then you've got the boundary extensions proposed in 2023 in light green, and those proposed in 2024 in yellow.
Yeah.
And then you've got in blue the minor boundary refinements, and some of those I think do affect Hazelmere, don't they?
They do, yes.
Yeah. Okay. All right, we'll come back to that plan.
Hang on, can I just?
Yeah, go on. Sure.
Having
sure,
only
sure.
just seen this one, the minor boundary refinements. I'm just searching for them.
In blue, look, go to Hazelmere, sir.
Yeah, got it.
You'll see it.
Oh, I've
down
got
there.
some. That's okay. Yeah,
Yeah.
that's fine.
Yeah, I think those are there are some others dotted around, but those are the ones that affect Hazelmere. You can see them there. We'll come back to that plan in a bit more detail. Okay, so let's move on. I wanted to ask you next, in terms of the appeal scheme itself, that's obviously set out in a number of places, including the Statement of Common Ground. I think also set out very fully in our original statement of case at section 2, which is CD 5.1. We've already heard Mr. Pullen's evidence, but could you just run through very briefly for the inspector what's changed in terms of the design parameters and the scheme since it was submitted?
Yes, so the best place to go for that is the DAS addendum, which is CD 2.15.
Yeah.
Pages 9 and also pages 12. So post submission of the application in the summer of 2022, a series of updates and modifications to the parameters and master plans were undertaken following liaison with officers and in response to some consultee comments. You'll be aware that the EIA still tests up to 130 dwellings on the site. The original indicative master plan was for 124 dwellings. That was reduced to 111. There was originally to be 2 dwellings at the site entrance, so the lodge and one a bit further up into the site. The second one obviously is no longer there. That was removed, so there's only 1 dwelling at the front of the site now. In addition, the existing green corridors, wildlife corridors were retained with some enhanced planting proposed between landscape character areas 1 and 2. So those are now shown on the parameters for approval, and some additional landscaping was proposed at the main site entrance as well, along with a reconfiguration of the retaining wall for the site entrance road.
Good, thank you. Now, can we turn to development plan and relevant material considerations? And again, probably worth having the Statement of Common Ground at NID 4.11 to hand. And this sets out at in various places that the policies which are most relevant to this scheme and I think, as we said earlier, that starts at the bottom of page 10. You've set out, and we know your position in your table 4.1. Can you just give an overall summary of what your position is in relation to development plan compliance across all of those policies that you look at in your table?
Yes, so you'll be aware through my table 4.1 that I do note some partial conflicts with some policies, and I'll go to those in turn. Though I do consider that the appeal proposal complies with the development plan when read as a whole.
Yeah.
And I say this on the basis that exceptional circumstances are demonstrated. That exceptional circumstances are allowed for not only by national policy, obviously paragraph 190 of the framework, but also policy RE3.
Yeah. Okay. Obviously exceptional circumstances are required for a development of this sort in the national landscape, both by paragraph 190 and RE3. What's Mr. Johnson's position if exceptional circumstances were demonstrated?
That there would be compliance with RE3.
Thank you. And then if we were to persuade the inspector that there were exceptional circumstances, what does that do in terms of paragraph 11D?
So that would, in my opinion, engage paragraph 11D, owing to the absence of a 5-year supply, sir.
Yeah. So if exceptional circumstances are demonstrated, would there be, in your view, a strong reason for refusal under paragraph 11?
So short answer is no.
Yeah.
I think it's probably worth noting as well that the framework, obviously, as you're aware, so was updated December of last year. The previous 11D referred to clear reason.
Yeah.
The new framework refers to strong.
Yeah.
So,
and I took Mr. Johnson to the government's response to the consultation, which emphasises that point. So I don't think we need to cover that any further. So that's 11D, which is engaged absence of 5-year land supply. If there's exceptional circumstances, not a strong reason for refusal, so the presumption remains in play. Just leaving paragraph 11 aside for one moment, what's the position in relation to LLP1 more generally? Is it out of date, in date more generally?
it's out of date.
And why do you say that?
Well, it's for a couple of reasons. It's over 5 years old.
Yeah.
The other reason is back in early 23, the council chose not to review the plan as up to date. They could have reviewed it as up to date.
So they could have reviewed it and said it is up to date,
Correct.
but what did they actually do?
Well, they put in play a new local plan process, confirmed that the plan was out of date.
Yeah. So as a result of the lack of a 5-year land supply, as a result of those matters that you've just referred to, you take the view LPP1 is out of date. What does that mean in terms of weight?
Well, it will vary by policy, sir. The policies that are still consistent with the NPPF can be given more weight, but those which are not should be given reduced weight. For example, the policies related to housing.
Yeah. Now, we'll come back to those other policies, for example, RE1 as well, countryside policy and stuff like that. But just on a point of principle, I don't think we need to spend a lot of time on this, but just for absolute clarity, we heard Mr. Johnson's view, but if a scheme doesn't comply with a policy or a part of a policy in the development plan, can it still be in compliance with the development plan as a whole?
Yes, of course. I do differ with Mr. Johnson on that point.
Yeah. Okay. Then if we go to, again, the statement of common ground, could we look at paragraph 3.12, where the document starts to run through the various policies? So I want to pick up the key ones that are in dispute rather than all of them necessarily. But can I just ask you this? So first of all, SP2, what's your view about compliance? And then also, what's your view about weight to this policy?
So I consider the scheme complies with SP2 as it is located at Hazelmere, which is a principal settlement.
Yeah. And that's the language that's used at Hazelmere.
That's the language that's used. in the policy, but the policy is out of date insofar as there's no 5-year supply, and obviously that sets the spatial strategy for the plan.
Mm.
But I consider that some weight can still be provided to it on the basis that the policy clearly does recognise a settlement hierarchy, sir.
Yeah. And then if we go to the next page of the statement of common ground, page 11, there are two policies, 3.14 and 3.15, ALH1 and AHN1. They're policies that you told me earlier you considered to be policies most important for the determination, albeit they're not in dispute with the council.
Yeah.
Position on those policies?
So out of date, yes, but the proposal complies because it's contributing towards at least 990 dwellings in Hazelmere over the plan period.
And on the affordable housing one, AHN1?
Complies, the proposal is at 35%
Yep.
provision.
Okay, then we come to, I think the next policy we come to is policy RE1, which obviously is in dispute. That's the countryside beyond the Greenbelt policy. What's your position on compliance and what's your position on weight in relation to that policy?
So the proposal partially accords on the basis that within our CA 1 and 2, there's clearly a significant change in circumstance, and I would acknowledge a conflict in that area of the site. But then you do need to bear in mind that there's large parts of the site where there's green infrastructure enhancements, so enhancements to the countryside. RE1 is, however, out of date insofar it's a countryside. It is a countryside policy which seeks to restrict the supply of housing, and therefore there is a partial conflict with the policy or partial compliance.
Mm-hmm.
But reduced weight should be given to RE1 on the basis of the land supply.
Thank you. And then I think we then come to RE3, which we've touched on already, but what's your position on compliance with and weight to RE3?
Yeah. So on the basis that exceptional circumstances are demonstrated, I judge that there is compliance with RE3. In terms of the weight of the policy would still attract a significant degree of weight on the basis that it is consistent with the NPPF. And the NPPF, in particular, the paragraphs to do with national landscape around 189, 190. So overall accordance on the exceptional circumstances and the policy could still attract weight. Mm-hmm. It's worth noting it's a footnote 7 restriction as well, as you know, sir, national landscape.
Yeah. And then in the statement of common ground, if you want to go on to page 12, there were two other policies not in dispute, but which you referred to earlier as being policies most important for the determination of the appeal. One is TD1, which is effectively design policy. That's 3.22, and at 3.24, NE1 on conserve and enhance biodiversity. Compliant or not with those policies?
Compliant with both. I won't repeat the evidence of Mr. Pullen.
No.
High quality design here is obviously not a reason for refusal.
Yeah. And
the biodiversity one is demonstrated through the SANG and the biodiversity net gain, all common ground with the council in terms of the provision on site.
Okay, and then if you go to page 13 of the statement of common ground, we've got going to LPP2, we have two policies cited, DM11 and DM15. So taking them in turn, what's your position on DM11?
DM11 concerns trees. My position is the proposal accords because of the additional planting proposed as demonstrated throughout the plan, sir. I acknowledge there is some tree loss at the site entrance. Those trees are mostly category C or U. So in coming to my conclusion on accordance, I've in a sense balanced the two, the planting versus the smaller amount of tree loss relative to the planting. Yeah, and also the woodland management, which is relevant in the
woodland management. Yeah. Because that's DM11, DM15. That's the one you've updated in your rebuttal table 1.1.
Yeah. Correct. So on that, I say partial accordance. The proposal's obviously technically in the rural area because it's outside assessment boundaries, sir. The policy has 3 criterion. The evidence shows that the site is at Hazelmere in a sustainable location. So that part is adhered to. The second criteria relates to both sort of landscape factors, natural beauty, but also the intrinsic value of the countryside. So that's why I get to the partial, if you like. So that's why sort of the policy is sort of similarly out of date. But the reason for that is the policy in effect repeats RE1 and RE3. So RE1 is to do with the intrinsic value of the countryside, which I say less weight should be given to because of the absence of a 5-year supply. But then obviously the landscape factors related to RE3, I say more weight should be given to because of consistency with the NPPF. So that's why I got to the overall partial accordance with the policy. But the policy itself should probably be given a degree, a lesser weight anyway, because it's referring to the intrinsic value of the countryside.
Yeah. Okay.
Oh, and the third criteria is not relevant because we're not protected agricultural land.
Right. Okay. And then I think if we move on in the statement of common ground, please, to the neighbourhood plan.
Yeah.
There are two policies that have been referred to. Only one of them's in the reason for refusal, but H1, which is not in the reason for refusal, and I think it's H1.3 in particular. What's your position on compliance with policy H1.3?
So that concerns the settlement boundary as well, which I say is out of date because the neighbourhood plan's out of date. It's a daughter document to the local plan. It wasn't reviewed within 6 months of adoption as the examiner required. So that is out of date. So I would give it reduced weight. But I do say that there's overall compliance with it on the basis that exceptional circumstances are demonstrated. Hence the proposal applies to national policy, and then there's a trigger in H1 which allows for proposals that accord with local or national policy.
Yeah. And it refers to exceptional circumstances.
Correct, it does, yeah.
Okay. So just in respect of the overall, you've gone through compliance, there's more detail in your proof. In terms of the weighting of policies, you've told us in relation to LPP1, it's over 5 years old. The council have deemed that it needs to be reviewed. There's no 5-year land supply, so therefore it's deemed to be out of date. So that's LPP1. What about the position on LPP2, which is obviously a more recently adopted document? Is that also out of date?
Well, it is because it's a daughter document to LPP1. The purpose of LPP2 service to provide some additional development management policies, but also to make allocations in Milford and Hazelmere.
Yeah.
So
and is the position in your view the same with the neighbourhood plan?
Yes.
Yeah. And you mentioned a moment ago that there was a requirement in the plan to commence a review within 6 months of the neighbourhood plan. Has that happened?
No, it's not.
Okay. So is there, you've obviously then in your proof, I think you deal with policies in the NPPF, don't you? The relevant paragraphs, I think that's paragraphs 4.11 to 4.23 of your brief. You set out the relevant paragraphs of the NPPF, and obviously the main ones in dispute are 189 and 190, which we'll come to in due course.
Yeah.
And we know also, of course, that the 24 NPPF didn't make any changes to those paragraphs. What has changed, though, in your view, in relation to the national context?
So quite a bit in summary. I think the first thing to probably go to, which I've mentioned briefly already, sir, is how paragraph 11 works. Obviously, the introduction of the terminology provides a strong reason. So, in my view, that's to strengthen the operation of the presumption. So, to refuse the development needs to be, meaty evidence, weighty evidence, and a strong reason. But also at paragraph D, Roman numeral 2, additional text was inserted that the decision maker should have regard to directing development to sustainable locations.
Meet that.
That applies here. Making effective use of land, well, I think that applies here in the context of landscape.
Yeah.
Securing well-designed places, well, that applies here. Providing affordable homes, well, that applies here. Plus, because of above policy requirements. So that was certainly an action to strengthen the presumption. Also, you'll recall, sir, there was a 12-month period where we suddenly had a 4-year housing land supply in operation in places. That went.
Yeah.
It's now a 5-year supply.
Yeah. And there were a series of changes to, I think it was paragraph 78 of the MPPF as it now is, and that's re-established the 5 year requirement.
So section 5 of the MPPF to do with housing did change quite considerably.
Yeah.
Notably 61. Obviously, the aim is to meet the overall need
Yes.
of an area again, significantly boost the supply of housing, which is
Yeah.
returning to some previous wording to an older
Yep.
version of the framework.
And I put to Mr. Johnson, obviously there were some deletions, weren't there, in paragraph 61, so that it no longer says meet as much of an area's identified housing need as possible. It simply says the overall aim should be to meet an area's identified housing need.
Correct.
Why is that important?
Well, it's important because the government is setting an objective to all local authorities to meet need, which is either set locally but via a policy on approach where there's an up-to-date plan.
Yeah.
There isn't one here. So if there's not an up-to-date plan, it's set by the standard method. And
Yeah.
the standard method before December of last year added up to circa 290,000 across England. The changes to the methodology in that standard method means it now adds up to about circa 370,000. And if each authority does their bit across England, then that will be the sum total of future plans, 370,000, which should enable 300,000 homes per year to be delivered, which will in turn enable 1.5 million houses in this parliament.
Thank you. And then you have dealt with, I think also in your proof, and we've put a number of these documents in NID 7, I think, but there have obviously been a number of other government statements about building the 1.5 million homes, etc. What have they done in terms of a change in the policy context nationally?
It's put a greater emphasis on housing delivery, but also I would point in particular to linking it to economic growth. The last Chancellor's spring statement, for example, was quite telling insofar as a key, if not the key contributor to UK economic growth was deemed to be increased levels of house building. There's been a number of positive statements to speed up planning and recognise the economic benefits associated with it.
Yeah.
But likewise, environmental improvements too, things
Yeah.
like the Nature Recovery Fund, etc., etc.
Yeah.
So those were recognising that new development can enable environmental enhancement as well.
And I think there was at least one reference in Mr. Johnson's evidence in chief to one of the government policy statements, and perhaps a suggestion that the government is looking for local plans to provide the answer to this. What's your view? Are we waiting for local plans, or is there something else that can be done?
Well, I mean, if we wait for local plans, then we won't get anywhere near the housing numbers.
Yeah.
Because circa 70% of England has out-of-date plans.
Yeah. And if we just think about the plan in this area, we know the timetable has slipped from where it was when we were at this inquiry last time, and we're now, the council's talking about, I think, summer 28. But what has the council done in order to get to summer 28, despite the delays that there have been? What have they done to the amount of time they've allowed for examination?
No, they've shortened it.
Yeah. What's your view? Is that realistic?
My experience is examinations take about 12 months plus on most plans.
And if this council decides, you know, as I think is certainly the intimation from Mr. Johnson's evidence, that it's not going to seek to meet its full needs, it's going to seek to have a constrained housing number, what's that likely to do in terms of the complexity and length of the examination, in your view?
I would expect the next examination in Waverley will be as complex as the last. There's a lot of interest. It's a Surrey plan. There always is.
Yeah. Okay. So how many years away realistically do you think a new plan is?
I mean, I think at the first inquiry, the adoption was supposed to be summer 27.
Yeah.
It's now summer 28. I think it's more realistic that the plan is 2029 earliest, based on just allowing for another 6 months for the examination process.
Yeah.
Essentially.
So if we wait for that plan, what contribution will that make to the government's 1.5 million houses?
Well, the next general elections in 2029, so it would be zero. Oh,
Okay.
sorry, it would be zero, lower.
Lower, yeah, all right. And then we know that there was a call for sites, which I think was underway when we were at this inquiry last time. It commenced about 18 months ago, I think. Any developments on that?
Nope. It's the process I mean, I recall submitting representations for this site in March of last year, 24. There's been no feedback from the officers yet, no updated land availability assessment.
Yeah.
And obviously no consultation events or anything on the new
No.
local plan.
And I mean, I put to Mr. Johnson that consultation, I think it ended, didn't it, in March 24? Are you able to submit sites through that
Well,
consultation?
it's not, right, I did listen to Mr. Johnson's response to that, obviously. I mean, you can obviously send a speculative letter
Yeah.
to planning policy. You could do that in theory, but there's no actual live active encouragement to submit sites at the moment.
Yeah. Okay.
Which stands in contrast, for example, to Guildford next door, where they've just kept the process live and ongoing.
Okay. And I think Mr. Johnson confirmed this, but is there any interim policy or mechanism that the council have in place to deal with housing now?
No, certain local authorities have that. Horsham, for example, has a facilitated appropriate development interim policy statement, but there's no such thing in operation in Waverley.
Yeah. Now, obviously, Mr. Johnson's view, both in his proof and orally, is that the way in which government policy is going to seek to meet this 1.5 million target is principally through grey belt and previously developed land. So before we come back to the plan, which we will in a moment, that we handed in this morning, what's your view about that? Is that right, not right, partially right?
Well, the simple answer is partially right. I
Yeah.
mean, the government is seeking new housing pretty much everywhere, I would say,
Yeah.
to hit the numbers. Now, obviously, there's a focus on brownfield. Fully accept that, and that is typically the most sustainable. But there's only so much brownfield land capacity, particularly in Surrey. There is an emphasis on greenfield, and the government, I acknowledge, have introduced the concept of grey belt.
Mm-hmm.
Nowhere in Surrey yet, and certainly not in Waverley, has grey belt been defined. So you can't find a plan.
Any grey belt review that you know of in train?
There's not that I'm aware of.
No.
Not seeing anything.
No. Okay. Thank you. And obviously, some authorities were able to bid to the government, weren't they? I put this to Mr. Johnson to speed up their plan process or go for early greenbelt reviews. Did Waverley bid for any of that?
Well, Waverley certainly didn't bid for extra funding to speed up their local plan.
No. Okay. All right. Now, can we just go back to the plan, please, that we put in this morning? So obviously the suggestion that Mr. Johnson makes is that in broad terms, there is going to be opportunity to develop brownfield and grey belt sites. And obviously that's what he says the government is principally driving at. So just on brownfield, I mean, you were involved in LPP1 and LPP2.
Mhm.
Yeah. What's the position in terms of supply of brownfield in Waverley?
It's very limited.
Yeah. Okay. And then on grey belt, I mean, I think Mr. Johnson fairly put that the council might have to have a further call for sites in relation to grey belt. Has anything happened in relation to that so far as
There's
you
not
know?
been a grey belt call for sites.
No, not been a grey belt call for sites. So just looking at the plan that we picked up earlier, I think we know, don't we, that in a situation where you've got green belt that's also national landscape, that can't effectively be grey belt. And we know, don't we, you put this in your proof that at an earlier point, before the grey belt policy had been fully defined, the leader of the council made representations, I think, to Parliament about the extent of grey belt. What in broad terms was the leader saying about the
Well, essentially, they don't think they've got anywhere near enough to meet the number.
Yeah.
So.
And I think there's a figure, isn't there? 7 to 12% of the green belt, it would not be, well, could still be grey belt effectively. And I think the 7 is based on if you extend the national landscape as per the proposals, and 12% if it's not extended as per the current proposals. So just looking at this plan, so first of all, can we just look at what's not green belt at all, first of all? So not green belt, not national landscape.
Yeah.
So there's obviously an area in and around Farnham and areas in and around Cranley.
Yeah.
In that sort of corner, right-hand corner of the site. Well, first of all, I mean, how sustainable is Cranley?
So Cranley's under policy SP2 is one of the main settlements, but it's sort of the fourth, if you like.
Yeah, has it got a train station?
No, not Not anymore, used
Not,
to,
not anymore.
about 50
Okay.
years ago.
Yeah.
So yeah, it's not got main sort of A trunk road
Mm.
accessibility. It's got an A road, but not.
Mm.
I think I'm right in saying it's the largest village in the country. I
Right.
think,
Okay.
but it's less accessible than Farnham, Godalming, and Hazelmere, all of which have larger roads near them or going to them, or railway stations, mainline railway stations.
Okay. And just, I mean, if you look at, we've obviously agreed, haven't we, a list of 18 alternative sites that we are going to look at for the purposes of this inquiry, which are sites that have been fed into, is this right, by both the council and the appellant?
Yeah.
Yeah. How many of those sites are in these non-Greenbelt, non-national landscape areas around Farnham, Cranley?
I think one's around. I think one or maybe two around Farnham.
Yeah.
These two, and then there's about three around Cranley.
Yeah. And what does that tell us, in your view, if anything, about deliverability in those
Well,
areas?
there's not a huge amount of known alternatives in those areas.
No. And then obviously we can see that there are areas of proposed expansion of the national landscape. Now, it may be said to you by Mr. Cosgrove, he might say to you, well, we don't know whether those areas are going to be finally designated as national landscape or not. But what's the position with those areas in the light green and the yellow? What is Natural England telling us about those sites, those areas now?
Well, Natural England has sufficient evidence in their view for those to be the very least valued landscapes, because those areas are meeting criteria which lend themselves to national landscape designation.
So where does that leave us in terms of if we exclude the green belt that's also national landscape, and we exclude the green belt that's already proposed to be extended to be national landscape, what does that leave us in terms of potential grey belt areas? Where are those? And
so you're probably getting yourself more and more familiar with the geography of Waverley through this inquiry, but there's land to the south and west of Godalming. So you're looking at the areas which is white in the background, just has the green hatches. So south and west of Godalming, land around Milford Station. So those all could be grey belt. Then the only other area sort of towards Cranley. So Cranley isn't surrounded by green belt, but nearly is. But if you go to where Cranley is and look northwest, there's some unconstrained green belt there, but that is pretty remote.
yeah,
It's not next to a settlement or anything.
Yeah.
And that's it.
yeah, okay. And can I just ask you this? Obviously, the other constraint that we've heard a lot about at this inquiry is the SPA. I think there are two SPAs that are relevant. Where are those SPAs in broad terms?
So the Thames Basin Heaths SPA, which isn't relevant for this proposal because of distance, but is relevant for considering the wider geography of Waverley. That is sort of northwest of Farnham and northeast of Farnham on this map. So it's in Hart and Rushmore, which are adjacent authorities, and the northeast bits in Guildford and Surrey Heath. So that's the Thames Basin Heaths. And then the Wealden Heaths is very much in this district. That's obviously between Hazelmere and Hindhead, and then to the west of Hindhead as well. And the west of Hindhead is East Hampshire district.
Okay, thank you. Okay, I think that probably deals with the plan for now. Can we turn to the matter of exceptional circumstances? You deal with this in your proof from paragraph 6.1 onwards. Would you just run us through, before we get into the detail of the sort of three criterion in paragraph 190, etc., are there any broad or more general points you want to make about the exceptional circumstances test?
A couple. So the first is that the exceptional circumstances test has been unchanged in the new version of the NPPF, and it's been pretty much the same now, I think, since 2012 NPPF. And that's important in light of the Section 85 Countryside Act amendments.
Yeah.
The second is that it's a development management policy rather than a local plan making test, which has been confirmed in a few other appeals, been turned in as one example. If you looked at that, so you'll see it's confirmed as a development management test. I think it's paragraph 798 of the inspector's decision. So that's important because even if this site was allocated for housing in a local plan or a neighbourhood plan, you'd still need exceptional circumstances to obtain plan permission.
Yeah. And obviously we've seen that on other sites like Royal School, which are allocated, but which still need to satisfy that test. And then just in terms of the overall context for the exceptional circumstances test, there are a number of other appeal decisions that you have referred to in your evidence, and obviously the most relevant ones are probably Turndon and Steel Cross, which is the Wealden one that's dealt with in the Wealden case. But can I just have you give an overview of why? Because obviously Mr. Johnson said he didn't think any of these were relevant, but just a broad overview of what you think are the kind of themes that one can draw from those appeal decisions, broad themes, if any, and why they're relevant.
Yeah. Okay. Well, firstly, I do respectfully disagree with Mr. Johnson on that. I think other appeal decisions and, if relevant, court cases can be material. The methodology for looking at alternative sites, that's obviously an important point. And so you should certainly look at Wealden for that, the Steel Cross case, but also Turndon, the approach taken there. Visual and landscape effects are clearly relevant in the context of the whole of the national landscape, and that comes across when you read Sonning Common, Winchwood, and also Turndon. The limited extent and degree of harm of a proposal is relevant, and that comes across in Turndon. I've said this already, but just for completeness, paragraph 11D, the presumption can be triggered if exceptional circumstances are demonstrated. That was the case in Sonning Common, Great Missenden, and also Turndon. And of course, housing supply and the limited scope to address the need elsewhere in the relevant district are relevant contributory factors, sir. And that came across in Great Missenden, Oakley Farm, and also Turndon. And then finally, I would point to the fact that in other appeals, such as Great Missenden and Oakley Farm, other planning factors such as a sustainable location of development were relevant. I think I should probably say, as a contextual point, that anything material can contribute to exceptional circumstances. Something doesn't have to be unique or exceptional in itself. It is a combination of factors leading to an overall decision.
Yeah. And I think I put these points to Mr. Johnson, but I just want to have your view, and I think this is one you've just dealt with. What's your view about whether what benefits can be taken into account in determining whether there are exceptions?
Any bit of benefit, they're not defined. So.
And where there are deemed to be limited or localized landscape effects, is that relevant?
That is relevant, yes.
Yeah. And what's the position with acute housing need and constraints? Is that relevant?
That is relevant, yes.
Thank you. Now, obviously, I think Mr. Johnson accepted that if exceptional circumstances were demonstrated, then the appeal would comply with the NPPF as a whole. Is there anything else you want to say about exceptional circumstances for the purposes of this scheme?
Yeah, I think, well, Mr. Johnson did say that. I think I would add it would comply with the development plan as a whole as well.
Yeah.
If exceptional circumstances are demonstrated. Yeah. I think so, and the map is quite telling. The borough is heavily constrained by environmental designations. In judging whether or not you consider exceptional circumstances exist here, sir, I think you need to have a look at the sustainable location of the site, edge of town. Of course, the landscape evidence, which I rely on Mr. Andrew Smith on that, but you should really consider all the benefits in the round and the
Mm.
weighting to those benefits in,
Yeah.
in making that.
We'll
conclusion.
come to those benefits in a bit. And then just on the Turndon case, obviously Mr. Johnson's view was he didn't think it was relevant at all, really. But just in terms of why you say it is relevant, can you just run through what you think are sort of key points in terms of why it is relevant?
Well, I say it's a similar scale of development. I think it's slightly large, isn't it?
Yeah, it's 165.
165, which
Yeah.
is about a third larger. So it's not, it is major development. So edge of settlement.
Mhm.
A key point is it had a similar scale of built area as a percentage. I think about 20%.
20% of the site built, 80% green.
80% green. So
Yeah.
quite similar to this case, which, as you recall, is 22% built, 78%
Yeah.
green.
And at the time of the inspector's decision, was there a 5-year supply?
There wasn't one at the time of the inspector's report. I think it was just below 5, about
Just below 5.
4.8.
Yeah, 4.89, I think.
Yeah.
And by the time the Secretary of State's decision, what was the position?
There was a supply, I think, on the basis that at the time the NPPF had a 4-year supply
Yeah.
requirement.
Okay.
Yeah.
In terms of the inspector's recommendation, what weight was given to the draft allocation and the emerging local plan?
Inspector's decision was limited weight
Yeah,
to the emerging plan.
but obviously the Secretary of State you would accept.
Yeah, the Secretary of State increased that to significant weight
Yeah.
because the plan had advanced through main modifications
Yeah.
at that point.
And then the conclusions about the level of harm in that case to the national landscape.
It concluded limited harm to the overall national landscape.
Yeah. Similar or different here on Mr. Smith's evidence?
So on Mr. Smith's evidence, similar to the situation here.
And what was the inspector's approach to alternatives? Did the inspector consider alternatives on the basis of alternatives to the scheme numbers or alternatives to need generally? Which
It was the alternatives to need generally rather than simply trying to find another site for 165 houses.
Yeah. Thank you. Now, Mr. Cosgrove may put to you that the Secretary of State doesn't necessarily endorse all parts of the inspector's reasoning, but what consideration does the Secretary of State give to any individual alternative sites in the decision letter?
So I can't see
No,
any.
can't see any. What was the position on policy conflict there?
Well, it did conclude some policy conflicts, but the inspector and Secretary of State gave reduced weight to those policies in light of the absence of a 5-year supply.
Yeah, the inspector did anyway.
Sorry, the inspector did,
Yeah.
because there wasn't one when the Secretary of
No.
State. So,
And then what happened, because there were exceptional circumstances, what did that mean in terms of the presumption?
as I've said earlier, it meant the presumption was engaged.
Yeah, okay, so that's Turndon for now. On Wealden, again, what was the approach that was taken to alternatives by the inspector? Was it to look at alternatives to the individual site or alternatives to the overall need?
The overall need.
Yeah, okay. And in terms of some of the points I put to Mr. Johnson about this, the Court of Appeal says when looking at need in what's now paragraph 190, you need to read it with other parts of the NPPF, the paragraph on boosting the supply, the paragraph on the 5-year land supply. So what's that telling us about what we should be looking at in terms of need, i.e. is it the scheme or is it the overall need?
It was the overall need. The NPPF refers to meeting housing needs, and includes a number of housing policies and the overall presumption policy on that basis.
Okay. All right, leave those appeal decisions. Can I just ask you very briefly about Sturt Farm? Sturt Farm is obviously a local consent for a larger number of units than the appeal scheme in the national landscape. Just in broad terms, how does it compare, in your view, to the appeal scheme?
It's similar insofar as it's slightly larger, just over 130 units. Edge of Hazelmere. In fact, so when you visit the site, it will not be difficult for you to visit Sturt Farm. It's less than 2-minute drive away to the west. It had a SANG, but a much smaller scale of SANG, about just over 3 hectares. And that SANG is to deal with its own impact rather than any wider developments. and was granted on the basis of exceptional circumstances, on the basis of the 2012 framework, but the test was still the same back then. And a series of alternatives were just looked at around Hazelmere, and it was deemed that this was the only site at the time that could be developed and delivered.
Okay. Now, I don't think we need to spend any time on this, but the position on access, I discussed with Mr. Johnson. Is the access at Sturt Farm, as you could see it today, the access that was permitted by the council when it granted planning permission on the basis?
No, it's not, sir. So you can go into the site now because there's properties occupied, so you can see it for yourself. That access was approved subsequently.
Yeah.
If you drive to the site from the appeal site, on the right hand side you'll see a wall in the lead up to getting to the entrance to Sturt Farm. The original proposal had the access going through the wall, up a hill and into the site.
Right, and that's what was approved in
That was also approved
officer's report.
originally.
All right. Well, we'll expect to have a look at that when he goes to see that. Okay. So can I just ask you, in your proof at 6.45 onwards?
Yep.
You run through a number of matters relevant to this scheme in the pages that follow. Can we just go through in terms of sort of headings for these? Really, there are a number of them. We won't necessarily take them all in this order, but where are we in terms of things like the sustainable location of the site?
I've said already, it accords. It's a site at Hazelmere. I don't think there's any dispute from the council on the site not being a sustainable location.
The degree of harm to the national landscape.
Well, I leave that to Mr. Andrew Smith's evidence. Obviously, the degree of harm is limited not only in a site-specific context, 22% of the site, but also in a national landscape-wide context, if you like, in terms of the small proportion the site is of the national landscape.
Okay, and then we've obviously discussed already the extent of the constraints that exist in Waverley Borough, both now. The national landscape, I think, is said by Mr. Smith to be 422 square kilometres, and potentially will grow by another 100 square kilometres if the Natural England proposals go forward. Mr. Smith also deals with what percentage of the national landscape do LCA1 and LCA2 that we would be building on represent?
Yeah, so that's obviously in his proof. I think it's as low as 0.00, quite a few zeros, 12%.
Yes, I think it's 0.00012%. Yeah. Okay. And why is that relevant?
Well, it's relevant in respect to the scale and extent of this development in the context of the whole national landscape is most certainly limited, but not very limited, not extremely limited. But on a more site-specific basis, clearly the vast majority of the site area is enhanced green infrastructure.
Yeah.
So.
Okay. And then obviously, in more generally, as we've said, landscape impacts, visual impacts, and any mitigation and compensation, though that's Mr. Smith's evidence.
Yeah.
Those are really obviously focused on LCA1 and LCA2. In terms of the landscape recreational biodiversity benefits, LCA3 to 7, those are again, I think, for Mr. Smith and then also Mr. Jack's evidence.
That's correct, yeah. I've
okay.
relied on their evidence in how I've drafted those parts of my proof, sir.
Okay. Now, we've also had a lot of discussion about compliance with the AONB management plan, and something that you cover in your proof. What's your position? Again, this has been looked at extensively by Mr. Smith, but what's your position?
It's my proof, page 66, sir. So nearly all of the management plan policies are relevant for the ecology and landscape businesses. I say compliance with the management plan as a whole. The planning policies, if you like, are P1 and P2 in the management plan. P1 is complied with because exceptional circumstances are demonstrated. And then there's an aspect to those policies on high quality design, which, as you know, sir, is not an issue between the council and the appellant. And I say that's complied with too, owing to there's a high quality design, the evidence of Mr. Pullen.
Okay. And then obviously there's been discussion of the Surrey Hills Environmental Design Guide and compliance with that covered in the evidence of Mr. Pullen and Mr. Smith. You rely on their evidence.
I
in
rely on
relation
that,
to
and it's certainly material, that design guide.
Thank
yes.
you. So could we then turn to, in terms of paragraph 190 of the NPPF, the first criterion is the need for the development and the impact on the local economy. So in terms of need for the development, I think section 8 of your proof, which is headed delivering new homes, looks at this position on need, and obviously we're focusing here on need across the borough. So what's evidence has the inspector got, first of all, about the 5-year land supply position from Mr. Neame, which is an appendix to your proof?
Yep. So it's common ground with the council. 5-year supply is 1.28 years, which is a deficit of 5,777 dwellings.
Yeah.
I might add, in my experience working in Surrey, which is, working in Surrey since 2017, Waverley's never had a 5-year supply over that period. But this is now the worst it's been.
Yeah. And what's going to happen on the 1st of July next year as a result of paragraph 78 of the NPPF?
So paragraph 78 will trigger an additional 20% buffer requirement on, you'll be familiar with how 5-year supply works there. So it's paragraph 78C. At the moment, that 1.28 years is calculated on the basis of a 5% buffer, not a 20%.
Yeah. And can I ask you this, in terms of the shortfall that we've got, both as a kind of percentage, but also as a number of houses, how does that compare to all of the other appeal examples that you've referred to and Sturt Farm? Is it better or worse?
The shortfall's now worse.
Now worse, yeah. Now, the council seeks to place some reliance on their housing delivery test performance, and obviously discussed that with Mr. Johnson. What relevance do you say that has, given where we now are on housing need?
Well, as was being said already, housing delivery test is looking backwards. That's the first thing to know. I think what is relevant, sir, is that, and if you look at Mr. Neame's evidence on this particular point, one of the contributory factors for Waverley scoring well on housing delivery test is the reduced requirement in the past 3 years. So I think it was 394 a year, 596 a year, and 617 a year as the requirement. And obviously that you calculate delivery against that requirement, which then gives a score above 100%. And there's reasons for that. One was COVID, of course, but all of those numbers sit substantially below the annual need under standard method, which is now over 1,400 dwellings a year.
Yeah, and I mean, I put to Mr. Johnson that given the need as it now is, in the future, their housing delivery test scores are going to fall off a cliff. He wasn't too keen to accept that. What's your position?
Well, they're very likely to fall, and the evidence is in the trajectories in Mr. Neame's evidence.
Yes.
You'll see the onward projected supply is going to be substantially below the need.
Yeah. So can we just look at that? Because obviously there's been a lot of focus on 5-year land supply, but Mr. Neame's evidence, which is attached to your proof, looks at a number of trajectories that go beyond 5 years to the end of the LPP1 period, 2032. Can you just run us through what, in broad terms, Mr. Neame has done and what those trajectories show us about need for housing going beyond 5 years?
Yeah, so the plan period, sir, has got about 8 years to run, as you know, to 2032. So not that long, really, to go. You'll be aware the NPPF seeks at least a 10-year projection of supply, if not ideally a 15-year trajectory. So what Mr. Neame's done is he's created 5 scenarios or 5 trajectories, and he's done this sort of policy on, as it were, policy off. It's a policy off, because he's looking at the known trajectory from LPP1 allocations, LPP2 allocations, and neighbourhood plan designations, But then in addition, in some of the trajectories, he's inputting some other known sites. So ones that Mr. Neame, myself and others know about because we know they've been promoted in the past, et cetera, et cetera. So to sort of introduce them, as it were, and this is page 19 of my appendix 3. The first trajectory is based on LPP1, LPP2, and all made neighbourhood plans. And that results in a shortfall against the need of 2,784 dwellings in the whole plan period, so 2013 to 2032.
I think we looked at this with Mr. Johnson, but paragraph 7.7 of Mr. Neame's report,
Yeah,
which is in this section, that's where you've got that figure you've just given, the
Yeah.
2784. But then the point I took up with Mr. Johnson was, for the inspector's information, if only the LPP1 minimum housing requirement is applied to this trajectory, there remains a shortfall of 1,695 units.
Yeah.
So, I mean, it may be put to you by Mr. Cosgrove that obviously there are parts of the PPG which suggest that where you've got national landscape, you may not be able to meet your full supply. You may have to have a constrained figure in due course. If you applied the constrained figure from LPP1, I mean, obviously that wasn't reflecting the needs they now are, but that's a constrained figure. Where are we on need?
well, even based on policy on constrained figure, it's minus 1,695.
That's trajectory 1. What about the other trajectories?
So the others, trajectory 2 is the same as trajectory 1, sir, but it excludes Dunsfold. Now you'll be aware the council have agreed as common ground Dunsfold's not in the 5-year supply. But in order to portray a situation whereby Dunsfold doesn't deliver a single dwelling at all by 2032, that obviously worsens the situation. So the figure policy on, so applying the local plan housing requirement throughout is obviously worse, minus 2,025 dwellings. Now the figure in Mr. Neame's evidence is applying standard method from the relevant point last year onwards. So that's obviously a worse figure, that's minus 3,114. So in a sense, trajectory 2 is the same as trajectory 1, it just removes Dunsfold. So then trajectory 3 is, if you like, the best case for onward supply. So that is including all the local plan part 1, part 2 and neighbourhood plan sites, plus other known sources of supply. So best case, and those sources of supply could be, for example, sites that were rejected last time round when local plan part 2 was drafted. So those emission sites, so those have been put in to this scenario. It obviously includes Dunsfold as well. Now, even on that best case of supply, the result is still minus 769 dwellings. Now, based on applying the, and that's based on applying the local plan housing requirement, constrained figure, the best case is minus 769. The reality is probably worse because obviously you don't apply the local plan constrained figure anymore because standard method is in play. That would result in a shortfall of minus 1,858 dwellings. So that's the best case from our knowledge of the borough and the other sites that might well come forward before 2032. And then the other ones just provided for information purposes really, trajectories 4 and 5, and they're obviously the worst case for supply, minus over 8,000 dwellings over the period, and that's basically because of the way Mr. Neame's applied standard method from the 1st of January this year in those scenarios, which is obviously a substantial increase in housing numbers. And the details it's just at the back of his proof, sorry, not proof, evidence. And you'll see that on trajectories 4 and 5. Oh, sorry, sir. Do you know what? Oh, page 19 and 20. Yeah. Sorry. I mean, the first trajectory, actually, to be clear, is on page 16. So that's trajectory 1, etc. The reason why stretches 4 and 5 are that much worse is that Mr. Neame has applied from this monitoring year, 24-25, 1,481 dwellings in every year up to 2032. Whereas in the other ones, he has not. He has applied the lower standard method figure of 710.
1481 being the new standard method
New-
number for
so
Waverley. Yeah.
There is an argument that that's a pretty credible one too. That 4 and 5 are actually the what is now playing out because of the fact that you apply a standard method unconstrained
Yeah.
as that number.
Yeah.
Now.
Okay. So in summary, where have we got to in terms of need? I mean, compare this position to the first inquiry. Where are we in terms of housing?
Well, the first inquiry, there was not a land supply, but it was, I think, in the end, like laying somewhere between 3 and 4 years.
Yeah.
So it's considerably worse than the first inquiry. With less progress on the new local plan than
Yeah.
than we
That's
had
fallen
before.
behind further. Yeah.
So the situation I would summarise now is critical and most urgent. I mean, we've got a very low housing land supply. It's of interest to, and obviously the evidence that Mr. Neame drafted for the first inquiry, the new evidence though is pretty much just a refresh and update. So this approach was presented at the first inquiry. And in the intervening period, the local authority, Mr. Johnson, they've not sought to criticise or rebut it or suggest any more sites other than those alternative sites that we're all familiar with at this inquiry now.
Okay. And then on need, can we just deal with a couple of other issues on housing needs? So first of all, in your proof, please, your main proof, page 83 and 84. So just switching for a moment from need in the borough to need more locally to Hazelmere and Hindhead. So without going through all the detail of this, you've set out in a table 8.1 a critique of the allocated sites in Hazelmere and Hindhead.
Yeah.
And at 8.13, where this gets you, your ultimate conclusion, is that there would be delivered 871 dwellings in Hazelmere and Hindhead against a requirement of what, 990?
At least 990.
At least 990. And that 990 figure, is that, what's that based on?
Well, it's based on the spatial distribution, SP2 and
Yeah.
ALH1.
And is that 990 based on an OAN or a constrained
It's
figure?
a constrained figure.
Constrained figure. And what do you understand in terms of the position that you've got to, having heard Mr. Johnson's evidence? I think we had some dispute about the position of the Royal School, and we'll come back to that one if we need to, I think a bit later on. But broadly, apart from that, where was he when I showed him this table and your analysis?
I don't. So, in terms of Mr. Johnson's position, obviously, I think we disagree on the Royal School, but I don't hear any overt disagreements on any of the other conclusions I made.
Okay.
In the table.
Okay. All right. So next topic, I think final topic on need, before we look at other parts of this, affordable housing need, which is dealt with in your appendix 2, the Tetlow King report. What are the key headlines so far as affordable housing need is concerned?
So you'll be familiar. This is appendix 2 of my proof, separate report by Tetlow King. I think that I'll just make an interesting comment. The council have not rebutted this. I didn't see anything from Mr. Johnson on it. And obviously, I think Mr. Johnson fairly accepted that delivery of affordable housing is an important part of the corporate strategy for the council. The report by Tetlow King goes through need first and refers back to the SHMA. And the SHMA is quite old now, it's 2015 for local plan part 1, that's CD 7.56. And that concluded a need of 314 affordable homes per annum, which is about 25 per annum in Hazelmere. But that evidence is now quite old. So what Tetlow King have done is use some updated sources of evidence to update the need conclusions. The more recent one is the Waverley Affordability Study, which is at CD 7.50. And that has concluded that the affordable need between 2020 and 2032, so a 12-year period, is now 770 affordable homes per annum. And it's upped it for Hazelmere. That figure now stands at 118 affordable houses per annum in Hazelmere, which if you add that up over a 12-year period is a big number. It's 1,416 affordable dwellings in Hazelmere over that period 2020 to 2032. So that's the need points, Mr. Marici.
So that's the need for housing. There's one other need issue I guess we should cover here, which is about the Scouts, I think, in particular, because there's a dispute about whether the Scouts need the facility that's provided on the site. And I just want to focus really in terms of the evidence we already heard in the first week of the inquiry from Mr. Buckler of the Scout group. We've obviously set out our position as to where the Scouts were at the last inquiry. That's set out in a number of documents. I don't want to go back to those. But in terms of the key points of where the Scouts are now, do the Scouts have a new lease?
No.
How long have these new lease negotiations been going on?
I think it was all triggered in 2015 originally, so 10 years.
Yeah.
Yeah.
So what certainty do they have about their long-term future in that situation?
Well, there's no certainty at all. And obviously security of tenure is an important factor for any organisation, particularly a charity.
And if they were to take the site on our site as their new base, what's the position there? Would they be leaseholders or freeholders?
They'd be freeholders.
There was a lot of discussion last time about whether the council's offer of a lease included a break clause allowing them to move the Scouts. And that was, I think, at the last inquiry said to be the sticking point between the council and the Scouts. What does that do about certainty if they have to sign a lease that allows them to be moved?
Well, it reduces certainty.
Yeah.
I think they'd have 5-10 years at most.
Yeah. And why are the councils, you understand it, interested in having this clause about relocating them?
Well, this is an interesting one, this because the site's it might be worth you visiting this one as well, but it's round the back of Local Plan Part 2 allocation DS04. The council have got aspirations as allocated for such for residential development, redevelopment of that site. Now, I actually have no evidence of this at all, but I mean, from my experience as a planner and in the development industry, it would make more sense for the Scout hut to be included in it as a comprehensive development of the site.
I think that's reflected in the council's closing at the last inquiry, that's a possible option for them. Just on this, just a few other points. So I think there's been reference in some of the documents, for example, the chronology that the Scouts put in last time, that at the background of these negotiations, in the background to these negotiations, what's going on in the background in terms of proceedings?
Well, I think there's court proceedings in abeyance, which were lodged in 2022.
Yeah. Okay.
And then in addition, obviously, the Scouts are operating on their present premises, but at a particular capacity. So
I think Mr. Buckler explained they've limited their intake and they have a waiting list because they got this uncertainty. So what would be the position if they were to move to the new?
They'd be able to expand.
Yeah. And how long have the Scouts been in Hazelmere?
100 years.
Yeah. And in terms of this new facility, how does it stack up compared to the facility they've got now? Is it better or worse?
I would say it's significantly better. There's more land.
Yeah.
There's a bigger facility itself, modern. So, and is on the urban edge, which is where they were originally 100 years ago before Hazelmere expanded.
Yeah. Okay. Thank you. Anything else you want to say about the Scouts and the need for that facility for now? No.
I think so. There was one point that did come up from a third party, and it was about shooting.
Yeah.
I don't want you to think that Scouts are young children running around with guns, but they have air pistols, which they use indoors only.
Yeah.
So that's probably the only thing I would.
Yeah. Okay. All right, so that's need. The final thing on paragraph 190A is you also have to look at the economic consequences of the decision. You deal with the economic benefits, don't you, in your proof, paragraph 677 and appendix 1, correct?
Correct, yeah. So
And I think also in your rebuttal at 4.3, is that
Yeah,
right?
and
Okay.
that evidence has led to my waiting.
Yeah,
on those.
okay. Right, so we need to move on to paragraph 190B. So I wonder if that's a convenient moment. I think I started at quarter 2, so I've been going for about an hour 20. I think we're probably on time to finish within a couple of hours or just about, so.
Yep, that's a convenient point to break. Just a couple of things. One point before I lose it that you raised, just to help me on this genuinely. I have done local plan examinations, but fortunately not for some time. Probably shouldn't say that. I'm obviously aware of the call for sites process.
Yeah.
You mentioned, I think, I know that in this authority, there was a call for sites, it stopped, and then you said, well, you could always go to the council in any event. You mentioned, I think it was Guildford, that had a sort of open call for sites instead. In your experience, which is more common, sort of finite call for sites or leave it open until whatever stage? Which
That's a
comes
good-
more
well,
often?
It used to be finite.
Yeah.
So I can understand why, because policy officers need to base date their LAR assessments.
Yeah.
As you know. Guildford is the only one that I'm aware of at the moment that it's just kept it open.
Just leave. Yeah.
Yeah. Let me just think about that fully. If there's anywhere else, can't think of anywhere else off the top of my head that just keeps it
Okay.
open.
No, that's useful. Okay, thanks very much for that. The other thing to pick up for the parties, there was the letter that I referred to this morning from Mr. Clark, who I think we pinned down as being present on day 2. I don't know if that's got to the appellants yet.
Copies actually which we can circulate.
I'm only conscious that you've got your witness here. Well, perhaps on that point only, obviously, if you could have a word to see if there's anything that this witness. Yeah, sure. Okay, so there's the Mr. Clark letter. The other thing was the question of the Scouts letter. I don't know if the council has seen that yet. This was a letter from firm solicitors called Gordon's Partnership. Came in, I'm not sure quite when it came in, to be fair. I think it might have come in just before the bank holiday, but it was sent to all 3 parties at 8:40 yesterday morning. And it was sent to Plan Consult, which I'm told is the standard method of contacting. So that went to the council 8:40 yesterday morning.
Mr. Marucci very kindly emailed me something at the start of, which may be the same thing. I haven't had a chance to look at it yet.
That's
So
it.
I'll probably get lots of them now. But thank you for that. I haven't had a chance to look at it, sir, but I suspect, having had an initial skim read, that it will raise lots of issues that will require further evidence.
Well,
Um,
that's why
so
I wanted
may
to
not be
pick
the
it up.
6th of
Because
May.
I'll be entirely honest with you. As a matter that I didn't think was going to come back in particular, I haven't gone through that letter with a fine tooth comb, but I have skimmed read it, and there's quite a lot in there.
Well, there are things that are contradictory to what Mr. Buckley said in answers to me for a start.
Well,
you know,
yeah.
I got some pretty clear answers from him, which is all I needed for my case on day 1 about necessity and being happy to stay there. And this raises a whole new, very serious issues, almost contrary to the instructions I've been given about engagement, saying nothing's been done as I understand it for well over 2 years or something, which is on my instructions just palpably wrong.
Yeah.
I mean, obviously I'll have to take instructions, so I won't be able to do that in a short break.
No, and I suspect, I mean, just thinking about timescale and what have you, I suspect that's probably not much for this witness.
Well,
Insofar as he's just this moment, given the evidence that he understands, I'm not sure if this witness can take us further. I'm not suggesting you shouldn't deal with it, but I'm not sure how much you can deal with it with this witness.
Well, I can't. I won't be able to deal with it with Scotland, not least because I haven't read it
No,
or,
sure.
or understand it myself. But all the tea. But I mean, in terms of some of the, I mean, he's made some points on the Scouts, as has Mr. Johnson, going to need. Clearly, this stuff is peripherally, theoretically relevant, but in the core of it, there's a simple point as to, I think, which I put to Mr. Buckley last week or 2 weeks ago. I'll have to have a look at it. So it raises lots of new issues on the face of it. Just having a quick
Yeah.
skim.
Have a look at it.
Yeah.
And I'm not suggesting that's something you can do over a short break, but we do need to pick
No.
up where that matter
We
goes.
do. So obviously, with Mr. Collins, I've stuck to stuff that was already before the inquiry because I have not read this material, and neither has Mr. Collins, I don't think, because we only got through this morning. So I've stuck to what we already had before the inquiry.
Yeah, sure. I think we obviously need to pick that one up at a slightly later stage. But yeah, let's all have a look at that letter. Okay, it is 10 past. Let's break till past, please. Okay, then let's resume. Just picking up on the 2 points we were talking about when we adjourned, the letter from Mr. Clark.
Yes, so I'm not going to tackle this with Mr. Collins. I think it mostly relates to cumulative highway impacts.
Yeah.
So two things. I mean, one is I think I'll just be able to deal with it in closing if I need to. But can I just reserve my position on one thing? Obviously, I haven't got anyone from highways on my side here, but if we think there's anything we need to reply to, we would like to do a short note. Could we? I don't think we will, but just I'd like to keep that open.
Yeah, that's fine.
But so apart from that, I won't deal with it with Mr. Collins because I don't think cumulative transport's really his thing. So no, he's shaking his head. So that's fine.
No, that's fine. I'll take it that that's a letter that's in and you can deal in closing. The other matter, of course, was the probably more thorny question of the Scouts letter. All I want to do is make sure that everybody has seen that letter from Gordon's Partnership, which I've got a note of 17th of the 4th, which I think must have been Thursday. That's the Thursday. We've all got that letter now. Yeah.
So
Okay.
I've got some paper copies if you'd like a paper copy or.
No, I'm fine. I'm fine with it. Obviously, that's a matter that particularly the council will want to consider, but I just wanted to make sure that we'd all got it. Okay, that's absolutely fine. Back to you then, Mr. Murray.
Thank you, sir. So I'm going to turn to look at paragraph 190B in a second, which is obviously the alternatives. Can I just ask you one other question? The inspector asked you about the call for sites. I just wanted to ask you this. Mr. Johnson mentioned when I asked him, I think he accepted, that it might be the council needs to do a further call for sites in relation to Greybelt, and he said that was a possibility. What's your view on that?
I could see merit in them doing that, yes.
Okay, thank you. Now, just turning to 190B, I mean, I think we've gone through already in respect of the Turndon decision and the Wealden decision, the approach that was taken in those cases, i.e. to look for alternatives to meet the full need rather than just alternatives to meet the number of units that are proposed. And I think you've made clear your position. Can I just ask you this? Are you aware of any appeal decisions where the approach that's being advocated by Mr. Johnson, that we only look at an alternative for 111 units, are you aware of any appeals that have endorsed that approach for housing?
I'm not aware of any housing proposal.
No. Okay, thank you. Now, I wanted to then just take this situation forward. If you have a situation, then if you follow those cases, Wealden and Turndon, if you don't have sufficient alternatives to meet the full OAN, what's the position? Is there an alternative?
Well, by definition, there isn't.
Yep. Now, can we just, before we sort of go into a little bit more detail about alternatives, I mean, it might be worth actually turning up. Could we just turn up your proof, please, at page 68 and 69? So you'll remember that we agreed with Mr. Johnson that the overall total you've got there for the alternatives of 822 is the correct one, and that comes from the statement of common ground.
Yeah.
Now, you get to, don't you, in terms of the number of available alternatives, 6, 5, 9, I think it is.
Yeah.
Yeah, and that's you excluding sites 1, 2, 3, 4, and 6. Now, just help me on this. The reason we exclude sites 1 to 4, which are all allocated sites, is what, in short?
Well, they're already accounted for because they're LPP2 allocations.
Right. So if we're looking at what the supply is versus what the need is and any gap between supply and demand, have we already taken account of sites 1, 2, 3, 4 in our analysis?
Correct.
Yeah. So Mr. Neame, has he taken?
They're in Mr. Neame's, well, all of Mr. Neame's trajectories.
Okay, all right. And then number 6, which you've excluded, is for 5 units. The methodology that we have used to select all of these other sites, most of which are agreed with the council, what does it say in terms of numbers of units?
Says 10 or more, I think.
10 or more.
Yeah.
And so is there any reason why this one's been included and not others?
I don't know why.
You don't know. Okay. Obviously, you've also included, haven't you, in that? So you get to your 659. You've got within that 659, haven't you, sites 15, 16, 17, and 18? Yes,
Yeah.
which are all in the national landscape, and which Mr. Johnson said that he accepted were not preferable to our site in landscape terms. So he removed them from his. And I think we got to, so your figure is 659, albeit you're including those 4 sites. The figure I got to with Mr. Johnson in the end, I think was 584,
Yeah.
which was his 822 minus 220 for those sites 15, 16, 17 and 18, plus minus 18, I think, for the grant of permission on one of the sites. Now, those figures, whether it's your 659 or his 584, just help me, how does that compare to the 5-year need shortfall?
Well, it's less than 20%.
Yeah.
It's,
And then we went through Mr. Neam's trajectories that go beyond 5 years to the LPP1 period, and I think the worst case was 8,952 negative, and I think the best case you told us was 769.
Yeah.
So even on the council's best case on those trajectories, as Mr. Neam puts it, as you put it, are there sufficient units either on your analysis or Mr. Johnson's analysis?
there are insufficient units.
Insufficient units. Thank you. And then remember, we also had that figure you gave us that under Mr. Neam's trajectory 1, if you just applied the LPP1 housing requirement, 590 a year, you get to minus 1695.
Yeah.
So how do those alternatives compare against that figure of minus
Well,
1695?
they're quite substantially below, actually.
Yeah.
Yeah.
Okay, thank you. Now, do you want to say anything about, in terms of the way we've done the assessment of looking at these alternatives? Obviously, this was started in the previous inquiry. Mr. McDermott did an analysis of various sites, and I think some of the landscape scores are obviously taken from his evidence that we've got in your table. And Mr. Smith has done some more. Is there anything else you want to say about that approach?
No, just to confirm that. So you look across both proofs, Mr. McDermott and Mr. Smith, for the full analysis, as it were. But I've left the landscape scoring to the landscape witnesses.
Yeah. Okay. All right. Well, then could we please just look at a couple of the alternatives? I mean, I think I don't want to spend much time on this, given I think the positions between the parties are clear on this, and it really turns on, are we looking for an alternative for 111 or the need? But just there are a handful of alternative sites that you recognise as being better placed than the appeal scheme in landscape terms. So can I just ask you a couple of questions about those?
Yeah.
So one of them, I think, if we look at the former, it's the former Longfields site. You agree that's sequentially preferable. It scores a landscape score of 1, whereas I think the appeal site's 4. Any comments about that site?
So, sir, you'll be aware that some neighbourhood plans are being made, some haven't. In Waverley, Cranleigh's now has been made. This particular site was in the draft Cranleigh neighbourhood plan, but has not been taken forward in the updated one, as it were. So it is in Cranleigh, in the urban area. It's a care home closed. Sorry, it was a care home. It closed in 2015. But there's no recent planning activity at all that we're aware of or can find from online sources. The other interesting, important thing to note on this particular one is that Mr. Neam did include it in his trajectory 3.
Okay.
So the absolute best case scenario includes this
Already
site.
includes his
Yeah.
site. Okay. So that would obviously affect the thing we just talked about was whether on that best case the alternatives would meet that need. But obviously we're actually kind of double counting there because Mr. Neam's already got it in that trajectory. But never mind, leave that aside. Then there's also, isn't there, the St Nicholas Junior School, Cranleigh. That's 75 units, which you also agree is a sequentially preferable site in landscape terms. Any comments on that one?
Well, similar to the last one, sir. It was a draft allocation in the neighbourhood plan, but was not taken forward in the final Cranleigh neighbourhood plan.
Yeah.
Application was refused in 2019 for 91 dwellings. My evidence is that it's still an active primary school, so it need to relocate to facilitate a development. And of course, and I should have said about the previous one, so alongside this one, obviously the capacities on them on their own is not sufficient for 111 dwellings, get smaller. But they wouldn't lend themselves, I don't think, to SAG either, in terms of the geography and location.
No. So, I mean, obviously, if you look at the numbers of units there, yes, they don't come up to 111, but as you say, they wouldn't provide SAG. What about Scout Hut?
Well, I suppose they could provide a Scout Hut. It's whether or not the Hazelmere Scout Hut wants to merge with Cranley.
Yeah.
In that particular
Well, it wouldn't be Hazelmere, would it?
Yeah, it'd be
That wouldn't be Hazelmere. That wouldn't be Hazelmere. Okay,
Yeah.
so that's fine. So they're Cranley sites, so it wouldn't provide a home for the Scouts of
Hazelmere,
Hazelmere. That's fine. And then the other one that you've got down as sequentially preferable in landscape terms on our own assessment is number 9, which is Lower Waybourne Lane, Badshot, Lee. So sorry, where is that?
So that's right on the district boundary with Rushmore. So it's north of Farnham, north of Farnham, Bagshot Lee.
Okay.
So it's not in the green belt. It's just countryside. So in constraint and planning terms, it is, I agree, sequentially preferable.
Yeah.
But it's sometimes never easy with some sites. It was a dismissed appeal a couple of years ago on the site. But I think that was in the core documents, CD 9.15 and CD 9.31. That's the inspector's decision on those. The applicant challenged that decision and lost in the High Court. And therefore, I think it's controlled by Bewley Homes.
So there's at least a couple of appeal decisions in
Yeah.
there and a High Court decision.
Correct.
Okay.
But also, just for completeness, that site is also in the trajectory 3.
Also, Mr.
David
Leeds.
Lee's best case scenario.
And is there any evidence, for example, that could provide strategic SAG like our site?
I have not got any evidence on that,
No.
but I don't think the site's quite big enough. Although the capacity is larger, sir, in that particular instance, there was a greater developable area
Yeah.
on the site.
Okay. And similarly, given its location, would it provide a new home for Scouts of Hazelmere?
Not for the Hazelmere.
No. Scout. Okay. All right. Thank you. I think we can probably leave alternatives. The last part of 190 is 190C, detrimental effect on the environment, landscape, recreational opportunities. And I think we know Mr. Johnson's case is focused only on landscape. He accepts there's no other environmental or recreational impacts. What's your position overall on this?
So yeah, I'll leave landscape to Mr. Andrew Smith. Obviously, recreation and the environment, I can make a couple of points. On the environmental issues, obviously the scheme's fully tested by EIA. There's no objection from key bodies on matters of air quality, noise, odour, transport, etc., transport effects, etc., etc. You can see that quite clearly from the original officer's report on the application. And then other issues such as drainage and ecology can be addressed by suitable condition or obligation, for example, on biodiversity net gain. So there are no detrimental environmental effects. Recreation is linked in part to landscape, but I would just make the point that through design and the improvements to the public right of way, so in particular by the side of the site, this development will increase, not hinder, it will increase, not hinder the linkages of Hazelmere to the national park and the national landscape beyond, the national landscape and the national park beyond. So it can only be good for recreation.
Thank you. So can we then turn to some other topics, please? We're obviously going to have a section 106 session, and there's going to be, I think, an explanatory note to the 106 in due course. But In terms of what's changed in relation to the Section 106 from the previous appeal, obviously one thing that was being pursued last time that's not now is the provision of some off-site allotments. That's gone. Affordable housing, the change is that there's an additional contribution of 200,000 towards off-site affordable housing. Do you want to say anything about that? Because Mr. Johnson was obviously a little bit sceptical about that, but how did that come about and what's its purpose?
I mean, as I understand it, it's agreed with the council. So where this has come about, sir, is that at the first inquiry, an off-site allotment was proposed, which does have a planning permission, which is sort of just east of the appeal site, along opposite the recreation ground. However, it essentially has become clear that despite local demand, there's no real sort of local desire for it, in inverted commas, in terms of delivery. There is a waiting list, but there we go. So that proposal has been dropped, and then the funding that was going to be used for that is now being directed towards affordable housing, and that equates to £200,000. In my experience, that's probably enough to fund a couple of small dwellings, a couple of flats within a wider proposal. That money will be available for Waverley to use in the locality, ideally Hazelmere Hindhead, and then it will cascade out to be used across the borough if they can't find somewhere to spend it in Hazelmere and Hindhead. So the scheme is now 35% provision on site plus £200,000 as an off-site contribution. So it's slightly above 35%. It's probably 36.5% provision now, in inverted commas.
Now, the other change, I think, is obviously on the last appeal, there was, before the inquiry, both a proposal for a 9-hectare SANG on site and a 12-hectare SANG on site. But there was no further commitment in the Section 106 to seek to deliver the 12 versus the 9.
Yeah.
That's now changed. Is that agreed in your understanding?
My understanding is agreed. Essentially, the 106 now commits as the first choice a larger SANG land proposition of no less than 12 hectares. So that is the starting point, if you like, and I'm sure through the process of implementing the 106, so that's where it's going to end up. So to make it clear, the just over 9 hectare element is in the area for full approval. To get to 12 hectares will require reserve matters on one piece of land, but that land is on the parameter plans as green infrastructure anyway. Space.
And I think we'll come to SANG in a little bit more detail in a moment, but I think in your proof you summarise, don't you, 7.6 of your proof. You say on the standard SANG capacity of 8 hectares per 1,000 new residents, a SANG of 9.69 would provide mitigation for 504 dwellings.
Yeah.
And then the position, I think, in relation to, so you say this total capacity up to 161 would be reserved by Scotland Parks Phase 1, leaving a net of 343.
Yeah.
And then the position for the 12 hectare.
I think it's above Mr. Morici,
Yes.
7.5. It's 7,464 dwellings.
Yeah. Okay. And then just one other thing on this 7.7, it's not just that we are providing the additional capacity. What's being done in terms of the price?
Well, the price is very competitive, as it were. I think he referred to it as a knockdown price when we were cross-examining Mr. Johnson, but it's about £2,500 a dwelling to buy capacity in this SANG, so when we go through the 106 in a couple of weeks' time, you'll see it's quite clearly spelt out at the front end of the 106 a cost per unit, which ranges dependent on the unit size, but it averages out at about £2,500.
Yeah, and you've given some comparable figures in Rushmore and Hart, where SANG is trading between 6,000 and 14,000, or
Correct.
Yeah. Okay. And I mean, just on the, we'll come back to, well, I suppose we can just look at this a little bit further in relation to Sang. I mean, the other point about Sang is that obviously on the larger Sang, the catchment increases. I think you explained that in 7.5, is that right?
Yeah, the best plan to look at, so is in Mr. Kite's evidence, which is appended to Mr. Jack's. There is a catchment plan, and a 12-hectare Sang goes out, covering the whole of Hindhead as well as the whole of Hazelmere, and a bit of Grey Shot as well. Sorry, sir.
I'll catch up with you in a second.
It's plan, it's map 2 at the back of Mr. Kite's proof, which is at the back of. Yeah. So you'll see on that, so there's 2 contours. One is the 9-hectare Sang, and then the outer one is the 12-hectare Sang. And you'll see that covers Hindhead as well as Grey Shot to the northwest. And on that plan also is the various local plan part 2 allocations as stars. And then the approximate area of the Sang is the blue line within the site area.
And the section 106, obviously, we talked about secures the Sang, imposes an obligation to seek to attain approval for the larger Sang. And there's also a Sang management plan, which I think is secured by condition. Is that right?
It's in both. It's in the
In both.
6
Okay.
conditions.
All right. Thank you.
Thank you.
Now, at the last inquiry, how did the council characterise what the Sang would be like in the appeal scheme?
Well, the previous planning was this was Mr. Eastham, and he described it as an ideal Sang. So which was greater than how I described it, to be fair.
Yeah. Okay.
It's a good
So
location.
We've talked about the capacity. So just on this, I don't know whether any questions will be put to you on this, but LPP2, in a paragraph we've looked at a number of times, says that below 20 units, you may not require any mitigation.
Yeah.
And leave aside legal points about habitats regulation assessment. It then says 20 plus up to 50, you need some kind of mitigation, but it could be HIPs. Could it be Sang?
Yeah, it could be Sang as well as.
And in addition, once you get to 50, you will need mitigation and you may need Sang, I think it says.
Yeah.
So in relation to that, what assistance do you say the appeal scheme would provide if consented for allocations that have not come forward, for example, like the Royal School?
It provides a credible and deliverable option or for those schemes. The evidence we've got from Natural England on this, I mean, we know there aren't any other Sangs in and around Hazelmere.
Yeah.
And we know that there's only so many HIPS, Heathland Improvement Projects. What we also know, sir, is that some of these sites in the town centre, so DS01, then DS02 and DS04, sorry, I'll repeat that. DS01 is the Hazelmere Quay site. DS04 is a Way Hill Youth Campus. And DS07 is the Fairground Car Park. They're all in close proximity to each other, sir, in and around that town centre and Way Hill. As you'll be familiar with how the habitat regs work and appropriate assessment, there may well be an in-combination need if all of those came forward together.
Yeah, even if they're all below 20,
Even if all below
you've got to
20.
look at the combination. Yeah, okay.
Right.
Fine. And I mean, obviously, I think it may be put to you that there's obviously been a recent grant of consent on one of the sites that we've been looking at as
Old
alternatives, Old Grove in Hazelmere, for 18
Mhm.
units. And we looked at the officer report with Mr. Johnson. And obviously it says at 18, they don't need to provide any mitigation. But once they reach 20, and we know that site's allocated for 40, they have to provide mitigation for all of the units.
Mhm.
So again, what assistance could the appeal site provide in relation to that?
Complete assistance. So,
Okay, so ultimately, what weight do you say should be given to Sang as a benefit in
Well, it's clearly needed, and it's a good location to have a SANG. And it can help bring forward other development in the local plan part 2. So I've attributed it substantial weight.
And then on a different point, but related point, there's also provision of biodiversity net gain, clearly in excess of any policy requirement.
Yeah.
But what's the position in relation to biodiversity credits?
The site will achieve at least, well, actually, to be clear, the site needs to achieve 1%. So because of the date of the submission of the application, but anything over and above can be offered as biodiversity credits. And on the basis of the evidence, the likely BNG is going to be over 20%, and therefore there will be some credits available for other sites to use.
Yeah, and is that dealt with in the 106?
Yes.
Yeah. Okay. So just a handful of other smaller matters that I need to just pick up on with you. So first of all, anything you want to say about housing mix, affordable mix, tenure?
Simply that obviously the actual market housing mix will be a reserved matter.
Yeah.
The mix for affordable will be set through the 106 and has been agreed with housing officers at the council. The site does lend itself to a balanced mixed community, 2, 3, 4 bedroom properties. Think I'll add anything more?
Okay, that's fine. And we'll obviously talk about conditions in due course, but I think one third party raised issues about drainage or flooding from Scotland Park Phase 1. Is drainage a matter that's agreed?
Yes, it is. There's no objection from either the Environment Agency or the lead local flood risk authority. There's suitable conditions to address the detailed drainage scheme.
Okay. And then again, this is sort of a slightly random collection of other points, but there's a previous law from 2020 which dealt with the appeal site. There's been some reference made, I think, to that, and the site, I think, was dealt with within that document. What weight do you give to that law, and how does it relate to where we are on the current law?
I would give limited weight to the present law, sir. It's 5 years old, and it was used to construct both local plan part 1 and then, sorry, as an outcome of the local plan part 1 process, but then to inform local plan part 2. The site in the law is reference 987, it's ID 987. And there's certain things in that which require an update. One is a site area. I think it's stated as over 36 hectares in the law, which clearly is in excess of what the appeal site is, so 23. I think what the law has assessed is everything. So the phase 1, the phase 2, Red Court House itself, and the outbuildings to it. Clearly, since 2020, there's been a significant change in circumstances. The phase 1 has been approved via appeal, 50 units. Red Court House itself has been sold and is now in separate ownership. And as you'll be aware, sir, through this process from 2022 onwards, a full EIA has been drafted for the rest of the site, which has addressed issues, technical issues such as noise, air quality, drainage, etc., etc. So I mean, it's complete speculation because I don't know, because I've not seen it, so it's got 0 weight, but I would expect that the next law will look rather different in respect of its scoring for this site.
Thank you. Now, I then want to turn to this issue about whether the appeal site could make a contribution to the 5-year land supply.
Yeah.
Now, in relation to that, what is the position with this site in terms of owner and developer interest?
The site is entirely owned by Redwood Southwest Limited, private individual, and that is the applicant. There is, at this present time, no option agreement or promotion agreement on the site. So the promotion is land, sorry, the application is landowner based, but there is developer interest, so.
And that's there's an attachment to your proof. Is that Elvia Homes who purchased phase 1?
That's correct. So,
And what's their position?
so I mean, Olivia Holmes understandably would be quite keen to buy the site if permission was granted.
Yeah.
Others would be too, I'm sure. But we did actually ask Olivia Holmes for their opinion on the basis that they're actively delivering next door as we speak. It's Appendix 6, my proof. So their view is that should you decide to allow the appeal, they would anticipate commencing development at the halfway point of next year, Q3 to Q4 next year, 2026. And they'd be looking to make completions late 2027, if it was them.
Okay. Now, I think the suggestion will be made, as it was at the previous inquiry, by reference to, for example, the Litchfield's report start to finish, that this site, because it's largely in outline, 110 of the units in outline, won't deliver any units within 5 years. So, I mean, first of all, there's obviously the Litchfield's report. I think we've got, haven't we? I think it's CD 8.8. Might be. Hang on a moment. NID. Oh, got both of them. NID 7. Sorry. Yeah. So NID 7.12. We may have it in twice. Yeah. Yes, Litchfield start to finish. I think we've actually got it in 2 places, but never mind. That's fine. That's good. So NID 7.12. Have you got that, Mr. Collins?
Yeah, so this is the first time I've had to test my find a call document thing. There we are, Litchfield start to finish. Now, I think the NID one is the updated one from March 24. I think the CD one is the one from 2020.
Okay, so this is the more up-to-date one. Okay.
Yeah.
So if we go to just looking, for example, at page 2, for example, as a summary here, it says 6 key conclusions, and one of them is only sites of 99 dwellings or fewer can, on average, be expected to deliver anything in a 5-year period from validation of a planning application, with the delivery of the first dwelling on average taking 3.8 years. Yeah. So first of all, in terms of delivery of the first, well, I mean, first of all, at that point, it says 5-year period from validation. So,
well, that would entirely match Olivia Holmes' prediction of summer 27, because the application was validated July 2022.
Yeah. And these are, as they say, figures on average. So what does that mean?
Well, there'll be some that are slower, some that are quicker.
Yeah. And then it also says here, obviously, it divides sites up, doesn't it, between those that are 99 or less, and then those that are, I think it's 100 to 499, I think it is. Yeah. So, I mean, on that scale, where does this scheme fall?
Well, on the borderline between two, the smaller band and the sort of medium band, as it were.
Yeah. Okay. So, what's your view then on possible delivery? I mean, do you think, even on the average that's given by Litchfields, do you think this site can or can't deliver within 5 years?
So, I think there's a few things to note here. So you'll be aware of the Annex 2 definitions. For if we were contending 5-year housing land supply in this appeal, we'd be talking about it for days, wouldn't we? But we're not in this particular case. But there's nothing that in guidance that stops a scheme with outline consent being within a 5-year supply. You just need good evidence that it can contribute. In this particular case, the scheme has been developed since the early part of 2022 in terms of all the technical work. All of the key technical constraints have been addressed. So with key consultees, so Natural England, for example, happy with the same. Lead Local Flood Risk Authority, happy with drainage strategy. County Council, happy with access, and the various transport initiatives, etc., etc. The outstanding point, as you know, and as everyone knows, is landscape and principle of development. So on the basis that were the appeal to be allowed, it was allowed in a couple of months' time, Redwood would start the site marketing summer of this year into the autumn. I anticipate there'd be significant interest, knowing the local market. Might be Olivia Homes who buy it, it could be somebody else. And I'd anticipate they'd spend the next 12 months after that working up the reserve matters and discharge of conditions, which takes us to sort of this point of next year. SANG delivery is easier in this location than in some others. The reason being is that there's already well-established green infrastructure on the site. Obviously that has to be delivered and in place before first occupation. But I don't think Olivia Homes' aspirations to have an occupation at the tail end of 2027 are that unrealistic. On the basis of a 2.5 year, that allows 2.5 years to discharge conditions, progressive reserve matters, and start delivery. So which means the site sits within the 5-year supply, which is obviously 24 to 29 at the moment, 2024 to 2029. I should probably mention as well that one of the houses is in detail anyway, so that can.
Yes, well, one's in detail anyway, so that's
just for completeness.
But yeah, that's fine. Okay, now good. All right. Now, just some other things to finish off. So first of all, we need to just tackle the issue of the previous inspector's decision. And obviously there's a legal issue about whether it can be or should be had regard to. And I don't particularly want to get into the detail, but if the inspector is against us on that and decides that some weight should be given to that decision, you've set out, haven't you, in Appendix 10, your comments or a number of comments on, and this is a joint piece of work, I think, by you and Mr. Smith.
And
Is
Mr.
that
Smith,
right?
yeah.
Okay.
Yeah. So sir, my position is that no weight should be given to the previous inspector's decision, but nonetheless, Appendix 10 and Section 10 of the main proof just outlines some potentially relevant paragraphs from his decision. The reason why I say no weight is obviously a planning decision or local plan adoption or whatever, a planning event, if you like, attracts weight when it's completed, adopted, decision made. And that operates on the principle that it has weight unless something else happens, which in this case obviously is a High Court challenge which quashed the decision. This is a fresh second inquiry. All the evidence has been updated, and you're considering, sir, everything with a complete fresh pair of eyes. Hence the approach to redraft proofs and update all of the evidence. We're not taking an approach here whereby I'm just talking to my previous proof of evidence. Everyone's had the ability to refresh and update their evidence. So on that basis, I think the main consideration is actually the evidence you're hearing at this second inquiry.
And in your proof at 15.9, again, on the basis that the inspector considers that some weight can or should be given to the previous decision, you've set out, I think, 9 points where things have changed or moved on from the last appeal. The one that's not included here that I think has been dealt with, certainly when I cross-examined Mr. Johnson, is that the previous inspector relied on the representations of Natural England, and obviously we've had further correspondence from Natural England accepting that their previous rep that was relied on may have been misleading.
Yeah.
Is that relevant in terms of changes?
That's relevant. They're the key body for SANG and landscape matters.
Okay. And then the other issue that we have to tackle in relation to this appeal is obviously we have a amended provision in relation to the statutory protection of national landscapes. That was in place at the last inquiry.
Yeah.
So that's not a change in terms of what was before the previous inspector. But what we do now have is the DEFRA guidance, which we didn't have previously. Can I just have your overall approach from a planning perspective about how you've approached the DEFRA guidance and the statutory duty?
So the duty itself and the DEFRA guidance, which expands on it, is of course relevant, and the duty itself is the law, sir. So I've had regard to it as I did last time, essentially, which is because it was still in play last time, but on the basis that the NPPF itself hasn't changed, paragraph 190 hasn't changed, I've adopted the same approach in terms of looking at the policy levers in inverted commas, because they haven't changed from the last inquiry to this one. To expand on that a little bit, obviously, I do appreciate that seek to further in the duty is an instruction to go beyond, is going beyond simply having regard to something. So there has been, that is something which needs to be considered by you as a decision maker. But the relevant places to look in how you apply that isn't just the DEFRA guidance, it's the AONB management plan and the Surrey Hills management design guide. And the way I've looked at that through my weighting of harms and benefits is whether or not the appeal proposal is taking an action or in its design is doing something which promotes or facilitates the various policies in that guidance and also the management plan.
So in relation to the 78% of the site, which is not being built on, but which there's enhancements in terms of planting and management, what's the position there?
Well, it's clearly an enhancement. It's clearly it complies and actually goes beyond the number of the criteria in the relevant management plan and design guidance.
Thank you. Is there anything else you want to say on the duty, or can we leave that one for now?
I just think, sir, the bottom line is you probably need to consider whether the proposal in its entirety is consistent with the purpose and has taken all reasonable steps to be so. So via its design parameters, mitigation, compensation. So you're looking at the appeal proposal in its entirety. So the green infrastructure as well as the far smaller area of built development. So.
Thank you. Now, can we finally then look at harms and benefits in the overall balance? And I think if best place to go is to your rebuttal at pages 13 and 14.
Yeah.
So just on, if we start with the issue of harms, I think you included in your list of harms greenhouse gas emissions from additional housing, which you said limited. I don't think Mr. Johnson does treat that as a negative. There's probably not much more to be said about that, is there?
No, I simply included that because the EIA refers to it. But I mean, to be fair, it's just because the EIAs always do that because it's the same for any site in the country, essentially.
And then I think probably on landscape, we've probably covered this. Obviously, you've relied on Mr. Smith's evidence in relation to that.
That's correct, yeah.
And it gets you to moderate harm overall.
Yeah.
And then loss of trees.
So I say limited to moderate on that purely on the basis that a number of the trees are category C and U. So and then I don't think it's as big a harm as the landscape, which obviously there is landscape harm. So I acknowledge that in landscape character areas 1 and 2.
Yeah, and there's landscape harm from tree loss, but what about arboricultural interest?
Well, I don't think there is any because on the basis of the quality of the specimens.
Thank you. And then if we turn to look at the benefits, which you've got in, again, in the table are 4.1 in your rebuttal, I just wanted to look at this. I mean, just looking at them, obviously, housing delivery, including self and custom build and affordable housing, you've got substantial weight to those, significant to the Scout facility, provision of land for the forest school, moderate to significant. Then you've gone through economic and other benefits there. In relation to Mr. Johnson's weightings, I just wondered any comments on where we got to with him, because on provision of SANG, including strategic SANG, you've given substantial. I think where we got to with Mr. Johnson was that he said significant, but only based on the 9 hectares
Yeah.
of SANG, not the 12.
Yeah.
Yeah. So if it was 12, where would you think Mr. Johnson would be?
Well, I'd hope he might be willing to go to substantial.
Yeah. And then B&G credits, you've already discussed about, you give significant weight to. What weight does Mr. Johnson give to that?
Let's get the. I think it's moderate. No,
Yeah.
sorry, I think it's moderate for BNG on site from Mr. Johnson. I don't think he factors the BNG credits from his evidence.
That's right. Yeah,
Yeah.
that's right. Okay, and then you've got improved access to the countryside. So obviously 78% of the site not currently publicly accessible will be.
Yeah.
What about links through to the national park? Is that relevant to that?
Yes, it is. Yeah.
And then you've got open space, landscaping, tree planting, AONB management plan objectives, significant. What did you understand Mr. Johnson's position to be?
I think in design terms, he said significant weight as well for those factors.
For design, yeah.
Yeah.
And similarly, you've got under design sustainable construction proposals, you've got modest to moderate.
Yeah.
We've got down moderate, Mr. Johnson. Where do you think we got to after hearing his evidence?
So I think it was. I think he was giving a significant benefit and then significant weight to the benefit on design. I mean, just to explain how I got where I got to that, the modest is the sustainable construction. The moderate is to the design. So I think it's a moderate benefit, which so you'll be aware the framework directs you to give significant weight to high quality design.
Is there anything else you want to say on benefits that we haven't covered?
I think that I think both Mr. Johnson and I do broadly agree on a number of aspects you've just gone through. Housing, SANG, B&G and design as sort of high level principles. I do think of any of the cases I've recently done or been involved with, this is most certainly one where you would give substantial weight to housing and affordable housing. And so I do remember as well, there's 5% self and custom build on the site also, for which there is a need and a waiting list and a requirement under the 2015 Act for the council to find sites for. I think that would probably be it on benefits.
Okay.
Mr. Marici.
And then, so can we just conclude then? Can we go to your proof, please, at page 117? And I was just going to ask you by way of conclusion, could you just please read 1524 to 1526?
Okay, thank you. Okay, overall, the appeal proposal accords with the development plan when read as a whole. There are some harms, though limited overall relative to the numerous benefits. Some of these benefits are in the public interest and hence also contribute to the exceptional circumstances required in this national landscape location, which in turn leads to my conclusion of overall compliance with the development plan and reasoning that the NPPF presumption in favour should be engaged. The inspector, sir, can have confidence that exceptional circumstances are engaged in this unique case. The appeal site is an exceptional one. The proposal incorporates 78% of the site area as green infrastructure to be enhanced, stroke managed. The remainder, development land, is recognisably well contained, directly adjacent to the principal settlement. And just to add to that point, so you'll note the very localised visual impacts of Mr. Andrew Smith's evidence. The proposal will create in perpetuity, as secured in the Section 106, a green settlement edge to Hazelmere at, in the wider context, a fairly limited cost. The proposal delivers identified needs in a well-designed fashion, including homes, affordable homes, and for the local scout group stroke forest school. The SANG and BNG credits assist wider development delivery in the Hazelmere and Hindhead area. The new DEFRA guidance of December last year amended the obligation on decision makers from having regard to protected landscapes to seek to further the purposes for which these areas are designated. There is a requirement for the decision maker to balance all its legal responsibilities, i.e. also to deliver housing, and hence new guidance does not take precedence over other public needs. It also encourages authorities to secure enhancements. By that I mean enhancements to the natural environment and landscape. The appeal proposal has a number of credentials which ensure that the majority of the site contributes positively to the protection enhancements of the national landscape. Furthermore, the proposal assists in creating enhanced public access to the national park and beyond. In my view, sir, it's quite simply good planning. A range of planning obligations, conditions and 106 obligations will make the proposal acceptable in planning terms. On this basis, we do invite you respectfully to allow the appeal.
Thank you, sir. Those are all our questions. Thank you.
Thanks very much, both. Okay, let's take a break now. It's 20-ish past. Let's resume at 1:15, please.